Thank you everybody for joining us today. My name is Kyle Patterson and I'm from Bryson, and today I will be your host. So just so that everybody knows a bit of a back, Bryson Insurance is an insurance broker here in Ontario, and we focus on delivering exceptional value to our clients. Before we begin the webinar today, I recommend that everybody takes a few minutes to review the wording in your policies, your insurance policies around employee practices liability. If you have a standalone employee practices liability policy, it's extremely important to review that wording now. If you are a client of Bryson, obviously reach out to your dedicated team and they will be happy to review that wording with you. And if you're not a client of Bryson today, feel free to review that wording, and if you need help, reach out to me and I can connect you with one of our team members. Our hope is that you never obviously have to rely on this policy, because you take the advice of things like this webinar and put all the right practices in place. But if you do, you want to make sure it's there to respond when you need it. And you know, one of the areas that we try to bring value is through bringing in incredible and knowledgeable thought leaders. And today we are extremely grateful for the opportunity to have Mathias Link join us from Fasken Law. Just a little bit of background on Mathias before I hand it over to him, so we dive right into the content. Mathias has advised and represented employers with respect to labor, employment, and human rights law matters for more than 15 years. His practice includes defending employers in wrongful dismissal actions, human rights complaints, grievance arbitrations, certification applications, certification applications, unfair labor practice complaints, claims under the Employment Standards Act 2000 and Canada Labour Code, as well as disability benefit claims. And you know, there's actually a lot more that's inside of his bio. He does a lot. And so you know, this is the opportunity for you guys to ask the questions. And so without further ado, Mathias, the floor is over to you.
Great, thanks very much, Kyle. I appreciate it. And just to dovetail from what you're saying, I know sort of people have questions, and so in terms of doing a practice run for this presentation, I've made sure that we left a significant amount of time at the end to address those. And hopefully what will happen as well is some of the burning questions that you may have right now will be addressed by the presentation itself. If not, we can tackle those at the end during the Q&A. So again, as Kyle said, welcome. My name is Matt Link. I'm a partner at Fasken, practicing labor and employment law. I know, I think most of the attendees here are dialing in from Ontario, and you're likely provincially regulated if you're outside of the province or a federally regulated employer. Fasken's practice group is a truly national one, with offices across the country. During this period of COVID-19, as you can imagine, as you're aware, as business owners, as HR professionals, changes in laws, guidelines, directions have been coming fast and furious. So Fasken has developed a COVID-19 knowledge center along with our daily update called HR Space. You can access that all for free through our website. Basically, we provide daily updates on changes to legislation, guidance, other developments. And we have to do that because, frankly, that's how quickly the law is changing as it relates to COVID-19, and particularly as it relates to employers and employees. So, the agenda for today is to largely cover 4 topics. Again, it's interesting, and I think the webinar is quite timely because Ontario employers have only within the last 2 weeks, the majority of the public health regions within the province have moved to stage 2 reopening. Yesterday, those of us in Toronto, I think we're quite happy to know that Toronto Public Health and also Peel Region Public Health moved to stage 2 as well. And so that leaves, by my count, only Windsor-Essex at stage 1. And the reason for that is due to an outbreak there amongst the agri-food workplace in that region. So talking about reopening your workplace, I think, is sort of really quite timely for many employers within the province and frankly outside of the province as well. In terms of the 4 areas we're going to generally be discussing, first of all, considerations for reopening your workplace during COVID-19. Second is best practices concerning the workplace as it relates to health and safety during the pandemic. I'm just going to briefly talk about some additional precautions that you may want to or may be required to take if you're an employer in an office setting or an industrial establishment. And then lastly, the one that's probably the most challenging and gives employers sort of the most headaches is dealing with employee absenteeism, work refusals, and the duty to accommodate during COVID-19. So we're starting with general considerations for reopening the workplace during COVID-19. I figure best early on in the presentation to get the sort of legal and legislation stuff out of the way. But I think it's important even just to keep in the back of your mind in terms of, why are these, have these restrictions been on us as employers over the last number of months, certainly going back to mid-May. Where do they originate from? And if, in terms of changes going forward, what should I be paying attention to? So the legal framework really is made up of 3 parts. I think the most interesting one for, certainly for lawyers, is with respect to emergency management legislation. I mean, this is really quite remarkable stuff. It's usually only used historically during war times. In Ontario, the particular piece of legislation is called the Emergency Management and Civil Protection Act. And again, it's legislation that is not used lightly because, of course, orders issued under it have dramatic, some say have had draconian impacts on businesses, essentially ordering certain businesses to shut their doors until further notice. It's quite remarkable in terms of the powers under this act. Similarly, as the province moves through the stages of reopening, what we see is orders under that act allowing employers to open up. And again, as time has gone on, what we see a movement between certain employers that have been deemed essential services to date and have only been allowed to reopen really for the bulk of this pandemic period, to now finally some non-essential services being allowed to reopen. So that's good news. But again, the orders under that legislation have been amended at least 3 or 4 times over the past couple of months, sometimes in the dead of night. And so it's an important piece of legislation to keep in the back of your mind and understand that, there are going to be continuing changes sort of going forward. Again, if there's another outbreak going forward, and hopefully this doesn't happen, but a partial closure, that's the legislation that the government's going to be looking to. Second piece of legislation relates to public health authority guidance in Ontario. It's the Health Protection and Promotion Act. Similar provincial legislation across the country. Essentially, this allows the Ministry of Health to manage, regulate, communicate concerns to the public about public health in the province. And it also allows both municipal and regional public health authorities to issue public health warnings, guidance, assistance to the public. So a couple of weeks ago, I think with the Welland County Public Health Authority issued guidance that sort of it was mandatory that masks be worn upon entering any retail establishment. And so they're drawing upon that legislation to make those orders. Third piece of legislation which all has existed all along, but which is something to keep special mind of during the pandemic, is occupational health and safety legislation. I'll talk a little bit more about that later on. But again, in Ontario, the Occupational Health and Safety Act has put forward a regime of internal responsibility that employers have for keeping their workplaces safe and to ensure that the workplace is free of hazard. And as you'll see when we get to it, that can include keeping them safe from COVID-19. During the pandemic, what we've seen arise is particularly through work refusals engaged in by employees. We've seen a number of situations where a Minister of Labour inspectors have had to come to the workplace and issue orders, either dismissing the claim or, knock on wood, to date, out of, I think, last count of 120 or 130 work refusals, only one stop work order was issued by the ministry. So we got the legal framework out of the way. Let's move on to talking about the steps you want to take as you're contemplating reopening the workplace, or if you're already open and you're sort of struggling with how to manage everything, your best approach or options to take. The first thing you want to do is create a multidisciplinary task force. You may have already had in place such a similar team, typically referred to as sort of business continuity or an emergency response team, but they should be converted again into a COVID-19 workplace reopening task force. Essentially, they've got to have a level of authority to both establish and coordinate communications protocols between management and employees. This is a confusing time. Employees are bombarded with information from all quarters. And so ensuring consistent, coherent responses to employees about your reopening plans, giving them an avenue to raise concerns and to discuss challenges is critically important. The task force should also consider any office reopening and re-entry issues, develop processes to deal with that, and again, continuously monitor public health and governmental guidance. I can't emphasize that enough. I mean, what is fortunate, I've said this to clients over the last number of months, had the pandemic happened, when I started practicing 17 or 18 years ago, where online resources just really were, quite minuscule. You're quite fortunate as employers now that, public health authorities and all levels of government have highly sophisticated websites and do regularly update them. And simply, in some cases, just using Google and entering a question gets you to that government website and answers your question. And so in terms of the excuse of, well, I didn't know where to look, or I wasn't aware of this public health development, that information should be available to you. It's a matter of taking some time every day to quickly monitor any developments. Next thing to consider is contingency plans. So although we're reopening the workplace, and again, knock on wood, we haven't seen it yet here in Canada, and even in some of our other provinces that are further along in reopening, for example, Saskatchewan, Manitoba, British Columbia, there haven't been any setbacks yet in terms of outbreaks, for example, that would cause businesses either on their own to make the decision to partially shut down or at the direction of government to do that. We're seeing that in some of the more populous states in the U.S., unfortunately, and it's a challenging time where you've shut down your business, you've reopened, and then because of an outbreak, you've got to consider closing up again. And so it's important to have a contingency plan in place in the event that happens, a full or partial shutdown. Again, so that, if you're in the fortunate position that you're in a business or industry where you can operate remotely, and you may have been operating remotely already, to continue to do that. So ensuring that your IT infrastructure, cybersecurity is in place. You've got any supply chain issues covered, and again, critical roles covered in the event that, for example, a key employee becomes ill, that you have coverage for them so that your business isn't interrupted going forward. Developing written policies to address COVID-19 related workplace hazards is, of course, extremely important. COVID-19 and exposure to COVID-19 constitutes a hazard under workplace occupational health and safety legislation. And so you want to develop a policy that allows you to both identify the risks of COVID exposure and also to be able to respond to that. Depending on the size of your organization, you may need to include your joint health and safety committee or your workplace health and safety representative. Determining restrictions on reopening. This is an interesting point. It's been, and I've had a number of clients that have found this challenging, where their business has many facets to it. And certainly when the shutdowns were first announced and only essential businesses were allowed to continue to operate, there were some real challenges in terms of interpreting the legislation and understanding, okay, well, this part of my business is considered essential, so I can keep it open, but this other part of my business isn't, and so it needs to be shut down. And over the last number of months, those orders with respect to essential businesses have been amended a couple of times. So making sure you understand whether you're able to engage in a full or a partial reopen, and when you do that reopen, what restrictions are in place in terms of social distancing, the requirement to have your employees wear personal protective equipment, those sorts of things. Conducting a risk assessment specific to exposure hazard as it relates to COVID-19. Again, this dovetails with what I've talked about previously. And again, I think it's critically important in terms of situations where the layout of the workplace is perhaps not conducive to social distancing, where it's difficult to keep those 2 meters apart at all times. Conducting a risk assessment is critical before you allow your employees to return to work en masse. And if that is the case, that physical distancing is difficult, it may require you to consider changing the physical layout of your workplace to, again, as we understand so far, the virus needs a host in order to spread and to replicate. And so physical distancing has been shown to be the most effective measure to keep COVID-19 from spreading. If you simply don't have the ability at all times to keep your employees 2 meters apart, then there's other options that you may need to consider, including reordering or changing up the layout of your office, desks, creating physical barriers in certain, say, high traffic areas, for example. Thinking about paying attention to, for example, doors and whether it's possible to minimize touching. So using automatic push buttons, that sort of thing for higher traffic areas, perhaps even having someone assigned to monitor entry and to operate your elevators so that there's minimum contact that takes place. At the same time, you don't, it's simply because you're wanting to keep the contact to doors and entry areas to a minimum. You don't want a free-for-all as it relates to your security. So you'll want to limit the access points to the workplace. And that may be, for example, instead of having, three entries and exits used all the time, there's only one entry and one exit. It's helpful both in terms of helping to configure your workplace so that you ensure that there's a reduced risk of people not violating those social distancing requirements, but it also allows you to provide continue to control in terms of your workplace safety and security. Reviewing your policy on screening questionnaires and temperature checks. This is one that I know that I and my colleagues, really even not just in our office here in Toronto, but across the country, received very early on and are continuing to receive now. What can an employer do in addition to ensure that employees who are attending the workplace don't suffer from COVID-19? There is a couple of things you can do. The first and sort of a less intrusive one is to, if you don't already have one, prepare and then implement a policy that involves a screening questionnaire. So every time the employee attends work, they are asked a number of simple questions, as simple as, are you experiencing any symptoms that could be associated with COVID-19? Do you live with anyone, or are you in close contact with anyone who has been tested positive for COVID-19 or is experiencing those symptoms? And then finally, have you or anyone you live with or been in close contact with traveled outside of the country? And again, at any time, frankly, since March 14th, which is when the federal government issued the direction essentially that leaving Canada for any territory outside of Canada constitutes what's called a sort of a level 3 concern area, including the United States. So that's one step you can take. A second step, which although initially there was sort of a lot of concern in terms of pushback as to whether this might be problematic from human rights perspective, is conducting employee temperature checks. So you do have to keep in mind that conducting a temperature check, even using a scanning device that doesn't actually physically touch the employee's skin, that technically is a medical examination. And so you do have to have a bona fide or a reason that's supported, has a basis in need or fact in order to engage in screening. What we found, again, as we moved on through the pandemic, is that rather than employees and for unionized workplaces, unions pushing back on employers engaging in temperature screening, which is often what happens when employers wanting to implement a new invasive policy. For the most part, temperature screening has been welcomed by employees and unions, and in some cases they insist on it. Again, it is not foolproof in terms of detecting COVID-19. Of course, we have that period of time where employees can be asymptomatic, but it is a tool to help you, particularly if you're in a situation where you've had an outbreak in your workplace. Considering implementing a temperature check policy is something that we would strongly recommend that you consider. Some other things you can do in terms of your return to work plan is to stagger start and end times. Again, all of this is aimed at reducing the number of people entering and being in the workplace at any one time. That's not only start and end times, but also staggering breaks and lunch hours, so that, again, you're able to keep individuals in any enclosed space at a minimum. Dovetailing on that is implementing a phased return to the workplace. Now, this may be, you may be required to engage in a phased return to the workplace as a result of government order, or if it's done voluntarily, thinking about what makes sense for you. Who do you really need back at the office, and who is just a nice to have? And then secondly, also think about, are there any employees, for example, with underlying medical conditions, compromised immune systems, that sort of thing, where, you know, returning them to the workplace, even with all the controls in place, because of their higher risk situation in terms of potentially, if they catch COVID-19, perhaps you want to wait until later in the return to work process to bring them back to the workplace. Again, altering days when employees work in the workplace and then work remotely is another way. As you're building up your return to work practice, policy, and procedure and experience in reality, is to ensure that, for example, the certain core tasks that have to be performed at the office physically can be done so. But again, that you're limiting exposure, you know, again, until people in part become more comfortable, and as we move forward through the stages of the reopening process. Signage, post signage of new requirements. I can tell you, I've been largely working from home since mid-March. Our office building is in downtown Toronto, and I've had to return to work on occasion. And fortunately, you know, while we've been largely away, our landlord and the firm as well have sort of worked together in terms of really quite plastering the area with signage. Not only as it relates to things like access to certain entries or exits, but the way that one is supposed to walk, in terms the path one is supposed to walk, in terms of being able to keep those 2 meters apart. Signage as it relates to the use of kitchens, common areas, and of course elevator use. Again, you don't want to assume that people are aware of how they should behave. And so clear, bright signs for, again, things like entry points, personal hygiene. Again, you think that a sign about washing your hands or properly washing your hands shouldn't be necessary by this time. You'd be surprised. There is value in having that sign above the sink, even if it's simply to remind that employee, you know, to take that extra time to, you know, to scrub beneath the fingernails and that sort of thing. There's value in that. Conducting training on new policies and procedures. Again, having new policies and procedures, and this relates to COVID-19. It can relate to, frankly, any HR policy. The policy is only as good as the employee's awareness of that. And with that, of course, comes communicating your policies and practices to employees, to management, and to other stakeholders. And of course, if you are a unionized workplace, you'll want to consider the timing and the level of involvement and communication with union representatives about your organization's reopening plans, and again, any health and safety measures that you're taking that may not yet be in place, but which you're contemplating. So we touched on health and safety considerations for employers during COVID-19. We'll do a little bit of a deeper dive into those. Again, just some things for you to think about from a health and safety perspective, some of these may be obvious, some of them you think may be obvious, but you should still have guidelines in place, again, just in the event that employees have questions and they're able to then access those policies. First of all, creating specific guidelines on physical distancing. And that doesn't mean simply saying, okay, you've got to stand 2 meters apart at all times. It's frankly, how do you actually practice physical distancing in the workplace? And what steps are you as an employer able to take to ensure that you assist your employees in maintaining that physical distance space? A particular area that's always a problem is if you have a common lunch area, a meeting room, or cafeteria that typically during non-COVID times would be quite crowded. What steps are you able to take to ensure that employees respect that physical distancing? Again, it seems obvious that, the direction, keep 2 meters apart, not so easy necessarily in practice. And that's why it's important to have a policy. In addition to the health screening questionnaire and the temperature tests, another item that you may want to consider implementing is a daily self-screening protocol. So this applies to employees before they even attend work, and it's as simple as you get up in the morning, right? How are you feeling? Are you exhibiting any symptoms of COVID-19? Between the last time and this morning when you're scheduled to return to go to work, have any members of your household experienced symptoms of COVID-19? Have they done any traveling outside of the country? So again, engaging in a self-screening protocol, if that triggers any of those points, have a policy in place where they contact someone to advise them of that. So they're not actually having to show up at work and be screened or tested. They're advising the employer even before they leave work, look, here are these concerns that need to be addressed. Creating a procedure for reporting COVID-19 related illness. I mean, that means not only as it relates to the employee reporting them to the employer, but also your obligations as an employer to report employees who have tested positive for COVID-19. As it stands right now, organizations that have an employee who is tested positive for COVID-19 in the workplace have an obligation to report that to the ministry. In addition to that, to your public health and safety committee or your joint health and safety committee, and also if you're unionized, to let your trade union know. And again, the reason for that is COVID-19 positive test in the workplace then triggers a number of obligations, which we'll get to in a moment. Ensuring personal hygiene practices. It was interesting sort of early on during COVID-19, particularly with employers that have employees that work in the outdoors, in situations, for example, where there weren't washrooms or other facilities available. You had complaints about, listen, there's no ability for me to practice personal hygiene. So just making sure that the facilities and products are available, hand sanitizer, wipes everywhere, as I indicated, signs demonstrating proper hand washing techniques are critical. Ensuring proper cleaning and disinfecting. Again, you've likely heard that, of course, that the virus can live on certain surfaces for a period of a number of minutes to a number of hours. And so ensuring that your workplace and workspaces are properly disinfected regularly or more frequently than you would in a time outside of the pandemic. That means common contact surfaces, desks, cafeteria tables, stairways, handrails, elevator buttons, phones, computer keyboards, all regularly disinfected. Sharing of equipment should be discouraged, again, unless it's disinfected after every use. And if there is a positive COVID-19 test in the workplace, as an employer, you should have steps in place so that a deep clean of the entire workplace is undertaken before employees return. Talked about the importance of safe and clean eating areas. In terms of meeting spaces and having visitors attend work, the direction at this point in time from public health authorities is that we should still be discouraging visitors from attending to the workplace, and that any meetings that can be conducted virtually should be conducted virtually. If face-to-face meetings are required, then physical distancing should be followed. In terms of travel, of course, only essential business travel should be considered. You've got to be aware, of course, that if you're traveling outside of Canada, that once you return, there's a 14-day self-isolation requirement. And that poses problems in situations for either someone entering the country from another country. In terms of having a business meeting, how does that 14-day isolation requirement impact your ability to get the business done that you want in Canada, and then be able to leave in a timely fashion? Similarly, on returning to Canada from elsewhere, think about, again, how is that 14-day self-isolation obligation going to impact you? Something that has developed over the course of COVID-19, and which many people may not be aware of, is that certain provinces and territories within Canada themselves have public health orders in place which limit the ability of individuals to cross into their province, either limiting entry entirely except for a number of exceptions, or immediately upon entering the province being required to self-isolate for 14 days. The main provinces and territories right now in play are the Northwest Territories, Manitoba, New Brunswick, and Nova Scotia. Again, the limitations and restrictions on entering and self-isolation have varied and been amended over the last number of months, and we expect that there'll continue to be changes. But be aware of that. The idea that you can freely travel throughout Canada may be the case in terms of with respect to some provinces, but not with respect to others. So simply be aware. Check the public health authority website of the province that you're traveling to. In terms of guidance from government health authorities on reopening measures, like I mentioned earlier, we're fortunate now that the provincial government and regional public health agencies have sophisticated websites that include a lot of detailed yet easy to read information. I've included just 2 links here. The first one is a link to the Government of Ontario's resources on preventing COVID-19. And that includes individual guidance for perhaps 75 different industries, types of businesses in terms of the steps that you should be taking as you reopen the workplace to keep your employees safe. The second link is all about Ontario reopening. Talks about what businesses can open at what particular stage and what steps need to be taken. And if you're outside of Ontario, you'll find that the province that you live and work in has similar detailed online resources. So again, there's no excuse in terms of saying, well, I didn't know. That information is available to you. Just very quickly, some additional precautions for those of you in an office environment as you're planning for reopening. We talked about this physical layout changes. It's important to remember that, again, unless you own your space, that physically changing the layout may require the approval of your landlord or your property manager. So you're going to want to work together with them. Similarly, elevator use. This interestingly, I think, provides, I think, one of the greatest challenges for some employers in terms of reopening the workplace, particularly if you're in a large office building where hundreds, thousands of people, particularly during rush hour times, would be accessing your elevator. Well, how do you ensure that social distancing remains in place? It is quite a challenge. As it stands right now, the direction and guidance received from public health authorities, in which I think most office buildings and landlords have implemented, is that it's elevator use on every ride is limited to from two to three people at any one time. But again, you're going to want to work with, unless you own your building, work with your property manager and your landlord to understand what those limitations are, ensure that there's proper signage available so that individuals having to return to work are aware of those restrictions. A couple of other things to think about, and this has changed over the last number of months. Initially the direction was social distancing, don't need to wear face masks. They have a limited assistance in terms of preventing the spread of the virus. That has changed over the last number of months. And particularly as we're beginning to reopen and return to work, I think you'll find more and more that landlords, for example, will require the wearing of face masks in common areas, for example, of the building. So in the lobby, in the elevators, if you're using stairs, that sort of a thing. I know at least 2 or 3 very large landlords in downtown Toronto, for example, that have recently implemented this requirement. Some other things to think about: how your people travel to the office, and is it safe for them to do so? If you're taking the TTC, I think effective the second week of July, face masks are going to be a requirement on all public transit. For industrial establishment, just a couple of, again, some additional precautions that, again, you may not think about in the first instance. If you've got situations where, as part of the workplace, you have locker room, changing rooms, showers, and facilities, what are you going to do? What policies and practices will you be able to put in place to ensure that people are able to use showers or change rooms or locker rooms while being able to maintain physical distancing? Again, we suggest staggered start and end times and access times to assist with that. And of course, deep cleaning and disinfecting of those areas at the end of each day is important. What about situations where employees, by virtue of the layout of the facility and the work to be performed, simply cannot physically distance. What can you do? Some steps to take is to really think about, okay, whatever non-essential work that's non-essential here, let's eliminate that. Skin-to-skin contact work should not be carried out. If you're reusing PPE, make sure that it's thoroughly cleaned and disinfected after each use and not shared. Single-use PPE should be discarded. Regularly cleaning the insides of things like forklifts, company vehicles. If you have a business where you're receiving deliveries from transport trucks, supplies, that sort of thing, again, ensuring that there's as little physical contact with the driver as possible. So, on to the the final area where I think sort of we get the most questions from employers about COVID-19, and particularly as you're planning on reopening the workplace, is as it relates to employee absenteeism, work refusals, and the duty to accommodate during COVID-19. They are not simple issues, in part because of the overlap of legislation and policy and practices that may apply. When an employee is absent because they are refusing to come to work for any number of reasons, you're going to have to consider what might apply here. Is there a statutory leave of absence that may apply? In Ontario and other provinces, there are COVID-19 specific unpaid leave of absences that may cover that absence from work. What about the ability or the need to accommodate under human rights legislation? Legitimate refusals of unsafe work. Again, they've been minimal so far, but they could exist. What about an employee that has an entitlement under a policy to things like paid sick days, paid personal days? Should they be entitled to take advantage of those? And then if none of the above applies, what about engaging in discipline for an employee who engages in an improper work refusal? Talking a little bit more about statutory leaves of absence and human rights accommodation. Like I said, in Ontario and in virtually every other province, shortly after the kind of pandemic really hit its peak point, the governments of the provinces amended their legislation to add a new statutory leave of absence, which allowed employees to take unpaid leave for the period of time that A, they're sick with COVID-19, B, any period of self-isolation required in the event of a potential exposure to COVID-19, but also for reasons such as, for example, elder care or child care, where care facilities were closed down and the parent that needed care or the child that needed care no longer had access to that service. An employee may be required to stay home in order to do that. All of that may fall under statutory leaves of absence. And even if it doesn't, there is a second obligation to consider, and that is accommodation under human rights legislation. So, for example, employees who may have compromised immune systems, may have other health issues that make them vulnerable to the virus. You may need to consider, accommodating their request to remain home and work remotely, if it's at all possible for you to do so. Legitimate refusals of unsafe work. These do take place Fortunately, so far, the experience throughout the country is that the vast majority of work refusals for occupational health and safety reasons have been found to not be legitimate, and the employee has been asked to return to work. But if you do have such a situation, just be aware that occupational health and safety legislation sets out a very detailed process whereby an employee can refuse to work, where the employee must investigate that work refusal. And then ultimately, if the employee isn't satisfied with the resolution of their issue, you may need to call in the Ministry of Labor, Health and Safety Inspector, who will then investigate the work refusal and make a determination. What about situations where you have a generous workplace policy that allows for unpaid personal leaves, paid personal days, paid sick days? Look, all of those are or may be in play here in terms of addressing employee absenteeism related to COVID-19. The important thing is to just be consistent in your approach. So engage in a case-by-case assessment of accommodation for things like family status, so childcare, elder care. Look, allow employees to post their availabilities and arrange for coverage. Allow employees' children in the workplace if you're able to deal with any licensing issues that may be required. All those are things that you'll want to consider. What about some anticipated scenarios in terms of a refusal to return to work? So I just listed a couple here, and I started with the one that we get a lot of questions about this. What if you have an employee who simply just feels unsafe or fearful about returning to work because of the perceived risk of exposure to COVID-19 as they return to the workplace? Occupational health and safety legislation is quite clear that the feeling of being unsafe without any objective evidence does not support a refusal to return to work. Similarly, the feeling of unsafe or being fearful about catching COVID-19 without any objective evidence is not going to trigger the obligation to accommodate that employee under human rights legislation or make that statutory leave available to them. But the way you communicate this information to the employee is important. It can't simply be, listen, I don't care that you feel unsafe, too bad, so sad, you're coming back to work. I think it's important to address the employee's fears and concerns, and that can be either through a conversation or a written letter setting out the many steps and policies and procedures that you've put in place to ensure that employees can feel safe in returning and don't have to worry about their health and safety. What about having an elderly or an elderly person at the home, for example, if the employee themselves are elderly? I can tell you in the province of Quebec, the fact that an employee is over the age of 70 can itself be viewed as a risk factor, which may require you to accommodate and allow them to continue to work from home. Caring for an elderly person at home that doesn't have facilities otherwise available, again, that may trigger the obligation to accommodate under human rights legislation. Compromised immune system, other underlying health issue of the person or the person, family member at their home. Again, that is going to be a factor that you're going to need to consider. Look, is this a legitimate request for accommodation, and can we accommodate? And then finally, childcare obligations. It's quite clear that during COVID-19, it's a much broader spectrum childcare obligations that employees now have, and the obligation on the employer to accommodate those employees has expanded beyond what we had in pre-COVID times. So with that, I'm happy to move on to some questions and answers. And let me just...
I've got the questions for you. You can,
great.
because quite a few came through here. One of the first questions, and just before we even go there, thank you so much. That was, I was taking notes as we went. That was a lot of great information in such a short duration. I'm present that we are going to go over the 1 hour mark by a couple minutes. So anybody who does need to drop off for other appointments, feel free to catch all these answers in the recording. But the first question then is, a lot of companies deemed essential from the beginning have been operating, and some have actually sort of expanded throughout this. So they've already had, these practices in place and been operating efficiently. But now, as more of the province is opening, what should they be concerned about from a legal perspective now? I guess that is the question in its entirety. Like, what should their focus or considerations be?
Yeah, I mean, simply because you've been an essential business and you've been operating during COVID-19 doesn't mean that it's business as usual. The reality is that the government is continually changing guidance, again, as it relates to best practices, health and safety, which may apply to you. So, for example, we'll see what happens with masking in public areas. I think what we've seen is that certain local public health authorities have made it mandatory for employees to wear them. And I think as we are in the stage 2, and really the volume of employees returning to work increases, and it becomes more and more difficult for social distancing. I think that mask wearing as a mandatory measure, even for essential businesses, is something that the government is considering. So keeping on top of that, I think, is critically important. Also paying attention to legislative changes. This is outside the scope of this seminar, but for example, all of the provinces and now the federal government for federally regulated employers under the Canada Labour Code have made changes to their temporary layoff provisions, essentially suspending them. So situations where again, you may have kept your business open, but with a reduced workforce, laying certain people off and being wary of the fact that that temporary layoff time period is coming to its max. That's all changed. Now, it's either been, depending on the province or in the federal government, it's either been expanded, extended, or in the case of Ontario, for example, all temporary layoffs after mid-March have now been deemed to be unpaid leaves of absence under COVID-19. So keeping abreast of legislative changes and government health directions is critical, even if you've been operating throughout all this time.
Fantastic, thank you. Next question. An employer, let's just say they do package delivery for the simplicity of this, and sure, they have more deliveries now, but they're still not anywhere near the capacity before. So they have an employee refusing to return to work because they're making more on EI than they would if they returned to work right now doing the let's say per hour delivery. What's recommended there?
It's a great question. And it's something that in the early days, once the Canada Emergency Response Benefit was announced as complementing or supplementing the ability to receive EI, really the government rushed to get that out so that $2,000 a month could get into employees' pockets as quickly as possible. What they didn't think about even though I think a lot of employers raise that concern early on, is, well, what if in terms of those workers where, depending on what your hourly rate of pay is quite close to what the benefit would be? What's the impact going to be on individuals' willingness to return to work? And the thought was, well, they'll return to work, no problem. Well, that's not turned out to be the case. And it's turned out to be quite challenging. I mean, fortunately, what I can say in the example that you've raised is simply because the CERB, Canada Emergency Response Benefit, or EI, provides the employee with more of a benefit than the work that you have available, does not allow them to turn down the work. If you're recalling them, they have to be recalled back to work. And if after a number of warnings, including a final warning that their job is going to be terminated for job abandonment or insubordination, you can proceed to terminate their employment.
Okay, thank you very much. And obviously too, I guess if they continue to refuse, the potential of having a part or all of that CERB pulled back down the road potentially could be out there. So we won't go down that road.
Absolutely.
Question about questionnaires for screening. Are you aware of any templates available that are already kind of set out, assuming it's best to get an employee response in writing?
Yeah. I mean, those. I'm trying to think. So if you go on our website, our COVID-19 center, there should be questionnaire templates available on our website, free to access.
So we'll make sure that link's available in the email
Sure.
out, everybody, just so you're not concerned about that. And then as a follow-up to that, in terms of communicating to employees their responsibility to report COVID exposure, is there any guidance or recommendations there?
Yeah, I mean, look, it's as simple as you have first of all, if you test positive for COVID, I mean, the employer has a legal obligation, if they become aware of it, to report it to the Ministry of Health. So conversely, if an employee is exposed to COVID, tests positive, it's a very, very serious thing, because if they attend the workplace and then that infects other people, again, it's the thing that we're most concerned about, during this entire time. So I think you want to make it as simple and as easy for employees to report as possible. Let's say that they are, in the early days, I think people were afraid, well, if I report that I've tested positive, I'm going to be fired, I'm going to be sent home without pay. Well, again, fortunately, there are, you can't be fired because you tested positive for COVID-19. There's a statutorily protected leave that you'll take. And then secondly, the employee should be eligible for the CERB benefit. So although not all of your wages are likely going to be covered, certainly a portion of them would be. So just putting all those points together in a policy to encourage employees that this is not something that's going to be punitive, that if it does happen, and if they do test positive, it's critically important for them to let the employer know.
And just on that piece, has there been any cases yet brought forward for an employee blaming the workplace for causing them to obtain COVID, like to actually get COVID?
Yeah, I talked about the Ministry of Labor orders in terms of work refusals. Out of, I think, 100, and the last time we looked, it's over 120 work refusals. The one time that the minister found that there was, I think that it was reasonable to refuse work was where an employee was able to demonstrate that they caught COVID from someone else in the workplace. Again, it is still, on a percentage basis, it's still, quite minimal, but it can happen. And look, and I think the reason that it's been kept to a minimum is because employers, by and large, have been following both government and public health guidance in terms of that social distancing, the wearing of the masks, the cleaning and disinfecting, the physical barriers, when keeping the 2 meters apart becomes difficult. All of that comes into play. There hasn't been a claim, any kind of legal claim that I'm aware of yet in terms of an employee contracting COVID-19 in the workplace, but there is that one work refusal decision.
Okay, thank you. And I'm going to actually read this question and a couple of them just as they're written. So an employer, sure. a food manufacturing facility has implemented a PPE medical mask wearing policy. A beard net is also required if the employee has facial hair. So an employee refuses to wear the PPE and provides a medical note that he cannot wear the mask for medical reasons, which are not specified. He is a heavy smoker and he does self-diagnose as a claustrophobic. So the company has accommodated this individual by allowing the mask to be worn under the nose with the addition of a face shield on top. The employee still refuses to wear the PPE. He won't even try, saying that it's undignified to have to wear it. So has the employer done their job in respect to duty to accommodate?
Wow, great question. I will say, I mean, whoever raised this question, you've all obviously spent some time thinking about this, and you've spent some time, rather than just saying, you have to wear PPE, you've got to do it. You spent some time thinking about how to accommodate that particular medical condition. So kudos to you for that. And I think that there is value in having done that, because if we're now to the point where it sounds like it's not about a medical condition, it's about that he feels it's undignified. Well, whether you feel that wearing a mask is dignified or not is not a basis for refusing to wear a mask. Again, this is serious. This is a serious situation. And simply because you feel that an employee feels that a mask or a face shield looks funny is not a reason to turn it down. So I would say in that situation, I would prepare a letter to be provided to the employee's physician, and to set out all of the accommodations that have happened so far, the steps that the employer has taken, and indicate, look, is this sufficient? And if it is, then he is going to have to wear that face shield, or you may be going down the road in terms of potentially discipline, unpaid leave of absence, something like that. Listen, an unpaid leave of absence can sometimes do wonders in terms of an employee somehow feeling that these steps that need to be taken are somehow, there is dignity associated with them. But I think they've done a good job so far, and I think they can begin pushing back firmly in this case, because it sounds like the reasons are less than legitimate.
Fantastic, thank you. And I think you've addressed some of this previous for this next question. So employee one repeatedly expresses concerns about contracting COVID-19 as a result of employee two, because employee two lives with a healthcare worker. So employee one basically is worried about being in the same office as employee two, even though physical distancing is being practiced in the office. So in that situation, I guess if it went to that next step, and I guess there's two outcomes. Employee one contracts COVID, or employee one starts refusing to come to work. What's recommended there to prevent all of that outcome?
So the issue here is the coworker has concerns because employee two has concerns because employee one lives with a healthcare worker. Is that right?
Employee two lives with the healthcare worker. So
okay.
And then employee one has these fears that
I see. Yeah. Look, again, I simply being fearful without I mean, not to be difficult about it, but there are a lot of things to be fearful of in terms of going through your day. And I get it. I get the concern that in terms of a healthcare worker, okay, there's the potential for exposure. Well, look, the reality is that healthcare professionals in Ontario, are, if you look at the PPE that they're wearing, I mean, it is some of the most stringent regulations imaginable. And simply by virtue of the fact that someone lives with someone who is a healthcare worker, that's not a sufficient basis for a work refusal. It is a different story if that, obviously that healthcare worker or that employee tests positive or begins showing symptoms of COVID-19. But as long as the physical distancing measures are in place, the employee should have no legitimate reason to fear for their safety in the workplace. And again, you'd start off with hopefully, reviewing all the steps that you've taken to ensure that the workplace is a safe place for them. The reality is this: as long as you're 2 meters apart, the virus is not going to be transmitted to you again, unless this individual, for example, picks it up on a surface and then touches their face, for example. Sure. So, so the fear of exposure is not enough. You're going to want to ensure that, again, you take the employee through all the steps you've taken. And if they still refuse, then unfortunately you start down the road of, warnings and progressive discipline up to and including termination.
Fantastic. There's a couple other questions that have come in that I think are just, they might be quick, but they're good different angles to consider. So an elderly employee, 70 plus, insists on returning to work. If that employer contracts COVID, it's around that blaming the employer piece. So can the employer prohibit the employee from attending the workplace due to being high risk?
Oh, good question. This is the other way around. I think that, there you've got to be careful that you're not discriminating on the basis of age, right? It's not. I think what you do there is you would raise the concern, and I think it's legitimate to be asking the employee to get a simple note from their physician, for example, confirming that there's no underlying medical conditions that they may have that will leave them more susceptible to COVID-19, and that the physician has no concerns about the employee returning to the workplace. And I think if you get that note, I think you have an obligation to return the employee to work. The idea that, if they get COVID-19, if they're going to blame the employer, well, look, that's, again, it would be a workplace hazard, right? Just in terms of any other workplace injury. And we have, a comprehensive workplace safety and insurance regime in place to cover that. The employer is not going to be civilly liable or be sued by the employee for the fact that they were exposed to COVID-19. It becomes a WSIB issue.
Fantastic. Okay, thank you. And I get this question, I'm not sure if the employer is not wanting this to happen, or if there's an employee in here asking the question, but an employee who's working from home with a child can't do the job effectively because there's no daycare. Can that employee quit and just start collecting the CERB instead?
Oh. I think that if they're not able to carry out the job effectively, and there are no other avenues for them to make childcare arrangements, so that is essentially because of the fact that childcare facilities, daycare, schools are closed, that this parent is the only one that can engage in those responsibilities, and they can't work at the same time that they're taking care of the child. I think rather than quit, I think that the employee would have a strong case to say, I need to be placed on that COVID-19 related unpaid leave of absence under the Employment Standards Act, and they would then apply for CERB. So I do think it's a very real possibility. I think as an employer, you'd really want to kick the tires to ensure that it's a legitimate request, that they've really done everything they can. But unfortunately, this is, it's difficult times for employers in terms of placing obligations on you that you wouldn't have in, pre-COVID. Again, that what you're faced with, unfortunately, is a statutory leave of absence provision that is aimed at, protecting employees from losing their jobs if they're impacted by COVID-19 in certain ways. And that could include the need to having to take care of their child and not having to work during that time.
Okay, fantastic. So there's two more questions. I do see some typing. So if anybody who has additional questions, you will have Matt's contact information after this, or some other members of Matt's team to reach out to. So question, in terms of accepting cash, so service industry, what's the employer's responsibility in that respect in terms of, just general workplace safety? In
terms of the casual service industry?
Yeah, so I pretend like an ice cream shop transferring cash. What's the employer's responsibility to keep their employees safe with the transfer of physical cash? So physical touching, I think, would be.
Oh, okay. Yeah, interesting. Well, so I watched there was a piece on CBC a couple of months ago where they talked about the fact that the virus does not live or transmit on paper. Now coinage, it can, right? So that can be an issue. I think what you do and what most organizations have in place right now is you say, look, as much as possible, and frankly, even you can, to the point of insisting on exclusive use of electronic payment through your bank card, your credit card, using touchless payment, and saying, we don't accept cash. Or if it's cash that needs to be accepted, again, ensuring that, for example, your employees wear gloves. Very, very simple. So those are two steps that you can take to protect against any actual risk or perceived risk of transmission through the handling of cash.
Fantastic, thank you. And I like trying to guess the answers to questions. So here's the last question for today. So a workplace, I'm going to, consider it to be some sort of distribution warehouse or something like that. Before the shift begins, they have a pre-shift assessment. And so the employee is saying that they're 15 minutes late to start their shift due to the temperature testing prior to entering the facility. So should that employee be compensated for those 15 minutes?
Oh, good question. Yeah, I mean, look, and this sort of falls within the area of, historically things like travel time, for example. If you have a company vehicle that you're required to take home with you at night, should you be paid, the time it takes to drive to the customer site? And these are always sort of gray areas. I think that, the safest approach here is that if, again, you're implementing this policy whereby you're requiring your employees to have their temperature tested, and it's for the purposes of work, I think the safest approach, until we have a decision by an employment standards adjudicator, or for sure for unionized settings, this is something that for surely is going to be subject of a grievance arbitration, is to be compensating employees for the time it takes them to get their temperature checked. Now, the reality is, it shouldn't be taking this employee 15 minutes. In terms of, again, these touchless devices, we're talking about a 2-3 minutes maximum. That should be it. So I don't know, it sounds like they're maybe fudging their explanation a little bit. But again, for those couple of minutes that it should take for the temperature test, the safer approach is to pay them for that time unless and until there's greater clarity as it relates to whether or not that's something that you can require to be done on unpaid time.
Fantastic. And we'll cut the questions off there, but I know you have a couple other slides here just to speed through.
Sure, yeah. So hopefully we answered as many questions as we could. Again, I said this throughout the presentation. Feel free to, anything you've missed or if you've got questions or anything like that, feel free to access the firm's COVID-19 Knowledge Center. I can't tell you the amount of information and the hundreds of hours spent by our lawyers and associates in terms of preparing information on not only the subject of reopening, but on all issues as it relates to COVID-19 and the workplace. It's all free and accessible. It's easy to read. If you've got a question, it's more than likely you'll be able to find an answer in our Knowledge Center. Secondly, for continuing updates on COVID-19 and other matters, sign up to subscribe to our HR Space newsletter. As I said, right now, during COVID-19, we are issuing daily update bulletins about developments across the country. And they're just quick bullet points. I learn something new every day. And again, you just look at it for 30 seconds. It's invaluable and it's also free. And then if there's anything that I've talked about that you haven't had a chance to ask me, or if you'd like to speak in depth about any of the issues raised or other issues in your workplace, feel free to reach out to me. My contact information is there below for your ability to access. And thanks very much for attending. And again, please keep well and keep safe.
So Matt, thank you so much. It was a pleasure to have you. Give your time and your effort to this. I also just want to acknowledge Kim and Lauren, who are in the background, who have also helped in the world of Fasken bring this together. The amount of quality information, the insight, the humor inside of this challenging time is all greatly appreciated. So just thank you so much for making yourself available to be with us and to be with our audience today. There's a lot of people thanking you for giving all of this great valuable information. And I do encourage you to reach out to Matt and his team should you have any follow-up questions. And again, just here at the very tail end, make sure you're also reviewing the wordings of your insurance policies right now around that employee practices liability. If there's ever a time where it's a heightened sense of concern, it's definitely right now. So you want to make sure that policy is going to respond if you do have one. So thank you very much, everybody. Take care. This recording will be available tomorrow. Again, thank you, Matt. Have a fantastic day. Be safe, be well. Bye-bye.
Thank you.